Testing. Judge microphone 1. Judge microphone 1. Testing. Judge microphone 2. Judge microphone 2. Testing. Judge microphone 3. Judge microphone 3. Testing. Judge microphone 4. Judge microphone 4. Testing. Judge microphone 5. Judge mic 5. Judge mic 6. What was that? Yeah. And judge microphone 7. Podium microphone, testing podium mic, okay. One more time, podium microphone. All right.
Right?
Yes, sir? Yeah, I was gonna say, if you need to go stretch your legs, do what you gotta do. We got plenty of time.
persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court at Portland within the state of Maine, may come forth and declare it, and they shall be heard.
You can be seated. The matter before the court is Lincoln 25-379, State of Maine versus Thomas Koss. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to identify yourselves for the record, including the party you represent, starting with that appellant.
Good morning, Your Honor. Attorney Scott Hess, representing the appellant Thomas Koss.
Good morning, Your Honor. Kent Murdoch, representing the state of Maine.
Thank you. And Attorney Hess, if you're ready to proceed, we'd be happy to hear your argument this morning.
I am. Thank you. May it please the court. I represent the appellant Thomas Koss on appeal from his conviction for domestic violence criminal threatening. The only issue on appeals was an obvious error for the trial court not to include a self-defense instruction as to count 2. The case arose based on events that occurred on October 20th, 2023, when there was an altercation between Tom and his girlfriend. Tom was charged with domestic violence assault and domestic violence criminal threatening. At trial, the girlfriend testified that she was assaulted and that Tom had threatened to kill her. Tom testified in his own defense and in summary stated that he only put hands on his girlfriend to protect himself from her assault, and described in very specific detail how she had hit him in the face with a pipe, started throwing objects, trapped him inside the residence, and pushed him against the wall. The charging instrument didn't specify if the criminal threatening charge was based on Tom's physical acts, the alleged verbal threat, or both. During discussions about the jury instructions, the court indicated that the issue of self-defense was generated, but did not initially state that it was limited only to count 1. And it indicated the instructions were fairly standard, and that it doesn't take much to generate a self-defense instruction. The instructions were provided to the parties about 20 minutes before the court resumed the closing arguments, and the instructions were delivered to the jury. After a brief review, neither party objected to the instructions. The instructions provided to the jury recited the elements of count 1, provided the instruction on self-defense, and then recited the elements of count 2, but didn't repeat the self-defense instruction. Tom was acquitted of the crime of domestic violence assault, but convicted of domestic violence criminal threatening. After the verdict, the defense moved for a judgment of acquittal, arguing the verdicts were inconsistent, and that oral motion led to a discussion where it then became apparent that the self-defense instruction had not been provided as to count 2. And again, this appeal is limited to the issue of whether or not it was obvious error for the court not to provide a self-defense instructions to count 2. I'm happy to receive any questions the court may have.
Then let me ask you this. I mean, there was testimony, obviously, from the victim that he threatened to kill her. Mm-hmm. The state's closing argument specifically argued that the criminal threatening was based on the threat to kill her. That's at page 87 in the transcript. Mm-hmm. Frankly, defense counsel didn't even argue about that count. It was all focused on the assault. But why can't we just say it was based on the threat to kill her, and then he never agreed that he did that in the first place?
Well, the charging instrument, first of all, isn't that specific. And the crime
I understand the charging instrument isn't that specific.
And the crime of criminal threatening can also be committed through physical acts.
It can.
And you had those physical acts here that also...
It perhaps can. Mm-hmm. My point is, in this case, there was a verbal threat that, she testified to. Mm-hmm. He certainly didn't admit making that verbal threat. Mm-hmm. Why can't the verdict on criminal threatening be based on that and sustained on that alone?
Well, the threat that was made, allegedly,
was, I'm going to kill you.
Well, and also, too, I think the standard review in regard to justification instructions is you have to view the light in the favor most favorable to the defendant. And the fact the self-defense instruction was generated already based on the facts indicate that the underlying events were such that that was appropriate.
But doesn't that actually indicate exactly that, therefore, the jury must have based it on the verbal threat, since they found that the physical conduct was justified?
Sure, but a verbal threat can be self-defense. I mean, if somebody breaks into my house and they have a baseball bat and I say, I'm going to kill you, yes, that's non-deadly self-defense.
Understood.
But in that instance, you said it.
Right.
And isn't that the tipping point here? I mean, during his testimony, he gives an account of what occurred, and vastly different. He said, what I said was, stop attacking me. When is this going to stop? When is there, to that effect, clearly diametrically opposed to her testimony, which was, I'm going to kill you. I'm going to kill you. So in order to obtain an instruction on self-defense, doesn't the person have to commit the act for which they claim they had a reasonable fear that unlawful force would be used against them?
Yes, in order to raise a self-defense, you have to have done something in self-defense.
So you can't say, well, I didn't punch him, but if I did it in self-defense. That's not going to work, right?
Well, I don't know if you have to divide the lines that neatly, that if it's and or, but I think it's fair to say from the record that the parties were engaged in a physical altercation. Thomas acted in self-defense, and part of that self-defense was, if that statement was made, I'm going to kill you.
But he never admitted making that statement.
Well, the jury would have convicted him, as the court had indicated, perhaps based on making that statement. So whether or not he admitted making the statement or not, the facts when taken as a whole clearly
But doesn't he have to admit making that statement in order to use self-defense as a justification for making it? In other words, to invoke a justification, you have to admit you did the conduct.
Well, he admitted to the interaction between the parties. I don't know if he specifically said, I don't think he specifically said, yes, I made that specific
Isn't that a
threat.
problem, though, for the self-defense? Because in order to invoke self-defense as a justification for the threat, he has to admit making the threat.
Well, he didn't deny making the threat, and I think that the court and the fact finder can look at the circumstances and if this threat was made, what context was it in? Well, it was in the context of him defending himself.
I'm sorry, you're saying he did not deny making it? Is that what you said?
That's correct, Your Honor. That's my recollection of the record.
In other words, he wasn't asked specifically and didn't say one way or the other?
Right.
And so your view is that that's sort of, an implicit acknowledgement that he made the threat and it was part of his self-defense claim?
Yeah, I think it gives rise to the instruction for self-defense.
I want to challenge you on that, because he gave a very detailed account of minute details, start to finish, and the only words that he acknowledged using were this, when are you going to stop attacking me, and when are you done? He had the opportunity, after having heard her testimony, to admit or deny that, and by leaving that out of his testimony, isn't that a de facto denial of having said it?
I don't think so, Your Honor. I mean, during the course of the trial, I mean, the party may not, if there's 100 different factual allegations, the party may not respond to every single 100 factual allegations. And I think if we look at how this situation played out, I think all of the parties were really looking at it as one event. I mean, trying to split out, okay, the
Yes,
statement...
but there were two charges.
And whether or not they were based on the same events or different events, we also don't know that, because the criminal threatening charge didn't specify that it was based on a threat. I mean, if you put hands on somebody and you grab them, that can generate a fear in a person of bodily injury.
And in looking, I realize you weren't trial counsel here, but as I look at the closing argument of defense counsel here, the words criminal threatening or I'll kill you never appear. It's all about credibility of the witness. And apparently he rang the bell on that point, at least on the criminal assault charge. But at that point here, the jury listening, if they're listening, aware that there's two charges here, defense counsel didn't even talk about the words I'll kill you. So that's still ringing in the air. And then they're back in the jury room. They decide her account of the altercation is not credible, but the words are still out there. They find a guilty on that.
Well, again, it's not clear from the facts that the physical conduct wasn't part of the basis of the criminal threatening charge. You also have in the record the statement from one of the jurors in her editorials that self-defense isn't available for that comment, which isn't the state of the law.
We really can't go there to that article.
It is part of the record. So
It's part of the record, but it's not.
It's a newspaper article. Do we take judicial notice? Are we supposed to assume it's the truth?
Well,
What she said?
It was part of the filings with the court.
You
I
attach
understand it.
something, that doesn't mean it's admissible, does it?
Well, it is,
It was filed
part of the
below.
motion, it was
Yeah.
filed with the court.
It's a
I think
part of the
court can-
record. That doesn't mean we take judicial notice of what it is.
In the time you
also
have left,
don't
Can I
impeach.
ask you about the lack of request for the instruction, an obvious error for not to include it? I mean, the judge here went through a number of steps, providing first a discussion about what will be in there, and then the written version, and then giving it to the jury, and asking them again any additions and corrections. So counsel had multiple opportunities to say, I want a specific justification instruction on criminal threatening, but didn't do it. Have we crossed the standards for waiver at that point?
Absolutely not, Your Honor. I mean, a waiver has to be an express relinquishment.
But
And-
isn't
and the
this a
court's-
little different than the usual where the judge says, are you good with these? And they go, yes. Where there was a specific self-defense, it's on the radar screen, isn't it? So doesn't it look more strategic? It looks more conscious that he's saying, I want it for this and not for that?
Well, first of all, it's stated on the record after the fact that there was probably a mistake.
Yes, after the fact, when it's too late.
Right. But so also, if you what you just recited in terms of the jury instructions, having multiple opportunities to refer them, that's no different than every other trial where there's a copy of the instructions.
Which is
that
why
are
I'm
provided.
asking about the extra we have here, which is, oh, there is a self-defense for this count. I don't want it for that count.
It's no different than the other cases where the court has reviewed for obvious error when a party didn't object to the instruction.
Could this have been a strategic decision?
I
Because in order-
don't think so, Your Honor.
Really?
I don't know how that would have been strategic not to request a
Well,
self-defense
because
instruction.
if you argued to the jury and say, well, he didn't say this, but if he did, his fear was reasonable, and that would certainly water down his credibility argument?
I think that asking for, in hindsight, asking for that self-defense instruction, that there wouldn't be any strategic reason to
Well,
waive that.
it certainly highlights the prominence of the words, doesn't it? The fact that it wasn't requested because the counsel didn't want to highlight the words again. Everything depended on the words. That's what the trial judge said. The criminal threatening charge, as it was presented and proven, was dependent on the words, not the actions.
That was the judge's, I think the judge declined to make a conclusion as to whether or not the charge was based completely on the words or whether or not it could have included some of the other actions. There was that
But
discussion.
again, you don't believe it looks more strategic by virtue of the fact that you did have this on the radar scope, but didn't ask for the instruction with respect to the criminal threat.
Again, I don't see what the strategy would have been. It was a very obvious defense. I think the reason it was overlooked is because it was obvious that it would have applied given the fact that that this whole event was one course of conduct and the self-defense instruction was provided as to count one.
Thank you. Anyone have any additional questions? Thank you.
Thank you. May it
Attorney
please the
Murdoch, go ahead.
May it please the court. I think those questions kind of stole most of my thunder here. I was going to highlight all the facts that the court did. I also would just like to highlight that I know this was one continuous, this arose out of one course of conduct. However, it's two separate incidences. So in other words,
Well,
I
there's
think
two separate charges
Two
here.
separate charges,
So,
correct,
and
not
you
two-
can have two
I misspoke.
charges arising out of the same course of conduct,
correct.
as long as they're not lesser included, et cetera. So-
That's correct. And so I think the analysis here could be that was it necessary for Mr. Cost to criminally threaten her to protect him from the alleged DV assault that was taking place or the domestic violence assault that was taking place. I certainly think that you could find that and the instruction was properly given in count one, but I think a separate crime was committed that is you could separate from the domestic violence assault.
From the
that was
state's
committed.
perspective, the criminal threatening charge was based on the verbal threat that he would kill her,
That's correct.
and that's how you argued it.
That's correct.
Do you concede that words can be justified under self-defense?
Yes.
Okay.
Yes, I do concede that. However, in this case, I think if you look at this in the like, if you look at this in the best light for the defendant, he testified that he had control of her, the victim in this case, was holding her on the bed, was holding her arms and was saying, "Are you done? Are you done?" I believe those were the words. I don't want to misspeak. And there was no more physical altercation after that. She testified that, at that point is when he said, "I will kill you, I will kill you." So it's a separate, the threat is separate from the actual
And if that's the case, on the instructions here, there was no specific request for the self-defense instruction to apply to the criminal threatening.
Correct.
And I think you're arguing that that was a waiver, that establishes waiver under our fairly stringent case law on the topic. Is that still your position today?
That is my position, Your Honor, given what the court has already pointed out, that this was not just us, sometimes we're just handed jury instructions prior to, we have a chance to look at them and not really a chance to peruse them. These were deliberated consciously by everyone involved, and they were agreed to and presented to the jury.
So it's, in your view, it's a matter of degree that in a certain circumstance, if defense counsel has lots of opportunity to look at the instructions but doesn't actually object, that as long as they had plenty of opportunity to look at it, that from that we can conclude it's a waiver?
That's what the state is suggesting.
Don't-
Your Honor.
don't
Yes,
you
and
have-
and I know I haven't had much luck on this
But you
waiver argument before the court before. However, and I felt like I've had some strong cases. I think this is, if there's an example of it, this would be one. These were smart attorneys and a smart judge who viewed this case and made decisions based on how they evaluated the evidence and the testimony. And the defense attorney is very accomplished, and it could very well have been a strategic move on his part. As the court's already noted, the second count too was hardly even mentioned. The focus was mostly on the domestic violence assault and in the self-defense argument in that case, and that count. Sorry.
Counsel, I know that the state argued to the jury that it was the defendant's statement that he would kill her that was what caused her to be in fear of imminent bodily injury, but is it possible that the jury could have found that it was the defendant's conduct that put her in imminent fear?
I don't know that you can, and that's a good question, because I was viewing this in light of Williams and Glassman, where it was is the threat of deadly force. It's not, if the threat of deadly force is not deadly force. And I started to get bogged down in that. But in this case, I think this is completely separate from the force that was used. And the difference between actually this case and Glassman and Williams is, while those were threats with a handgun in both cases, there was no physical contact and there was no firing. In this case, regardless of who you believe, there was hands-on when he threatened to kill her. And so I think, yes, the totality of the circumstances would have probably put her in more fear. And I think she testified that the reason she reported this, she had said that there were other incidents of abuse, but the reason she reported this one is because he had never threatened to kill her before. This seemed to be an escalation. So I think that did play into her thinking.
So is that a yes answer to the question, that could the jury have concluded that it was just the conduct that constituted the threat?
Just the conduct, the actual physical contact?
The actual physical contact, yeah.
I hate to go into the minds of jurors. I don't think so, because I think, well, they could have, I guess. I can't say no with any certainty. But in this case, it was pretty specific, the threat. I will kill you, I will kill you, right? It wasn't... Yeah,
And how was it? It was argued to the jury that it was the words that formed the basis for the criminal threatening. In other words, you separated that out for the jury, is that right, in closing?
That's correct, yes.
And when we're looking at obvious error, because there was no request, if we're not certain which conduct might have formed the basis, what's your view as to who that helps? Does that help you or Mr. Koss?
I think it helps the state.
Is this a situation where, because they found that the physical conduct was justified in order to find him guilty, they must have based it on the verbal threat?
That's what I was thinking. Yeah, I think that's exactly right. I think this jury deliberated, I think, and thought about this and read those instructions and took them seriously, which is, I think, why we're here, because clearly they followed the instructions. But I think, yes, they determined that the physical contact was, at least according to the verdict, who knows why they determined that. But you could assume that it was because there was a self-defense argument generated. And once they determined that separately from that conduct, there was a threat that rose to the level of beyond a reasonable doubt and in the state's favor. I think as to who that tips for, that's a...
Well, we don't know at this point whether the not guilty verdict was based on the justification of self-defense or credibility of the witness, because as you know, during the cross-examination, defense counsel was pretty rough on the witness, pointing out prior inconsistent statements, and the jury may have simply felt that she was not believable on the degree of force.
That's correct, and that was one of the things I was thinking of as well. Is we hate to go into the minds and see why we have no idea why they found not guilty on one and found her credible. They certainly found her credible with the threat on the other, because she was specific about the threat. I guess this is another one of those things. Is it a waiver? He didn't deny. Say he didn't say I didn't kill you, but he didn't say he said I'd kill you. He said I said, are you going to stop now? Or are you going to stop now? So he contradicted her completely on the stand, and that's the jury found her credible and came back with a verdict of guilty.
Oh, could this be a case of, and going into the minds of the jurors is always,
That's why
problematic, but just a pox over both your houses. They didn't believe her with respect to the physicality. They didn't believe him when he never mentioned or how he described his response to the physicality.
Yeah, so who does that, that's another one. Who does that tip? Well, it tipped one way to the defendant and one way to the state. I think, I don't know that they didn't necessarily find her not credible. The state did submit photos of her that could, a reasonable juror could believe she took a pretty good beating during this altercation. I don't think he had any marks. I think he had maybe a couple marks on him, but there were some pretty good photos of her bruising. So I mean, you're right, I hate to go into the minds of the juror, but I would believe that they probably thought that they couldn't determine who was the primary aggressor here, but they determined that he definitely threatened to kill her, and that is separate and apart from the physical conduct here. I always wonder if I answered your questions.
Well, I'm looking to see if anybody has additional questions. It doesn't appear so.
Thank you, Your Honor.
Thank you. Attorney Hess, you reserved some time for rebuttal.
I did. There are 2 points I'd like to make. The first one goes to the question from Justice Lopez. I believe that the standard is whether or not a justification defense has been generated, that the standard review of this court is to view the circumstances in the light most favorable to the defendant. I have that in my notes from the research. I don't have the cite for
Even on obvious error, though? I mean, that's my question. When there was no request for it, what do we do if the record's murky?
So I think that's whether or not the court's analysis, right, is broken down in a couple parts, and one of those was the justification defense even generated by the evidence? Because if not, then
But that's the problem. With regard to the verbal threat, assuming it was generated as to conduct, but if it was it generated as to making the verbal threat? And I'm going to suggest to you that there's 2 things that might be missing. First, he didn't deny making the threat, so you can't justify the conduct if you don't admit the conduct. And 2, at the time of the verbal exchange, whatever it may have been, and if we take that, your point that, he didn't admit it, but he didn't deny it, he had control at that point. And so how can it be reasonable to believe that an imminent use of force is necessary at that point to defend himself? Do you see? So I don't see how it's generated either way based on the statement.
That's a question for the jury, and that's why the instruction should have been
the generation
given.
of it is not a question. Whether the instruction is generated is not for the jury.
But this court has to view the facts in light most favorable to the defendant as to whether or not that instruction.
But there is no contrary evidence that the verbal exchange occurred at a different point.
And if you're relying on the conduct, the jury acquitted on count 1.
Right. And that may very well have been because they didn't have a self-defense instruction on count two.
Well, and it can't just be any error. It has to be a plain error. So why do we look at it in your light most favorable?
Because fundamentally, a justification defense creates additional elements to the charge that the state has to disprove. And I think this is important when we're looking at the issue of waiver, because what waiver means is that a defendant is giving up the right for the state to prove part of its case beyond a reasonable doubt.
But as the chief noted, it's a little at least murky whether it was even self-generated. So don't we give the judge the benefit of at an obvious error standard?
Well, Your Honor, the record indicates that the court stated that it didn't provide that instruction because it viewed the threat as deadly force, not non-deadly force. So that was the court's reasoning for not providing
That's
the
also part of
instruction.
the after-the-fact discussion.
And it was, and it
Yeah.
is, the state pointed out, I mean, they're both experienced, very knowledgeable, well-respected individuals and jurists here. So.
Thank you. Any additional questions? Okay, thank you. We will take this matter under advisement, as is our usual course, and issue a written decision. Thank you.
All rise.
Good morning, you can be seated. The matter before the court is regarding the estate of Robert R. Young. This is Waldo 25-390. I see counsel are present, I'm assuming ready to proceed in this matter. We're being streamed on the web, both by audio and by video. And what I would ask is that before we begin the argument, that the attorneys who are arguing simply introduce themselves for the record together with the parties you represent.
Good morning, Your Honor. Jennifer Eastman for the appellants. Robert Young and Diane Young.
Brett Baber for Applee, Raymond Young.
Thank you. Attorney Eastman, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you. Good morning, Chief Justice, Associate Justices. May it please the Court. The foundational principle of the holographic will statute is to make the law accessible to all, to allow a testator, in his own words, by his own hand, to state his final wishes for his estate on the reasonable belief that his intent will be upheld, absent those execution formalities required for formal wills. The cardinal rule of testamentary interpretation is to give effect to the intention of the testator as gathered from the language of the document. If the holographic will of Robert Young does not stand, then the holographic will statute serves no purpose. If this is not a valid holographic will, then what is? It was undisputed that the holograph meets the statutory requirements of Section 25022. The material provisions and the signature were in the handwriting of the testator. The intent, as expressed in the holographic will of the testator, here, the words, "This is my last will and testament," controls the legal effect of the disposition. In over 7 years of litigation, the petitioner never challenged the facial validity of the holographic will. In fact, it was the opposite. His argument was always that the holograph was the product of manipulation, a valid will made invalid by some nefarious or malevolent action of the respondents. The respondents specifically requested clarification from the probate court on what claims remained to be heard after summary judgment was granted in the Superior Court. Lack of intent was glaringly absent from the list of claims to be heard at trial in the probate court. Despite the petitioner's failure to bring the claim, despite 7 years of pleading the opposite, and despite the court's exclusion of that claim when specifically asked what claims remained to be heard in the probate court, lack of testamentary intent was the deciding factor in invalidating the holographic will. The probate court blatantly ignored the intent of the testator as it was clearly written in the holographic will, in finding the will invalid based on extrinsic evidence that was inadmissible as to intent, where there was no ambiguity in the document. This court should vacate the judgment of the probate court and remand with instruction to grant the appellant's petition for formal probate of the holographic will of Robert R. Young. Thank you. I will take your questions.
You seem to be arguing that you can't go beyond the four corners to determine whether there's testamentary intent, as opposed to what the bequests or the intent of the document itself are. Aren't those two different things? In other words, the cases where we talk, and we talk about this in contracts, not just wills, et cetera, that when it's unambiguous, you work within the four corners of the document to determine essentially what it's trying to do, who's getting what is it that that person is getting, et cetera. But the issue of testamentary intent, in other words, whether this is intended to be the final will and testament, why can't that be done by extrinsic evidence? It seems to specifically contemplate that, in fact, under 2502 subsection 3.
So there are a few things there, Your Honor. First of all, subsection 3 allows extrinsic evidence to prove intent. It does not, by its plain language, say that extrinsic evidence is admissible to disprove intent. Now, granted, that is probably inherent in the statute, but if we
Well,
look...
isn't that neutral? Intent that it constitutes the will can be established by extrinsic evidence. Doesn't that necessarily include that it does or doesn't?
I think perhaps, but again, if we look at the underlying role of the probate court, it is to uphold the intent of the testator whenever possible. In this case, if there was some question regarding intent, there is a prima facie showing of intent on the face of this document. This is my last will and testament. It disposed of his entire estate. It was clearly made in contemplation of his death.
Is that at that point, though, a factual question for the court to determine? Is that it in fact intended to be the last will? Clearly, there's evidence that it could have gone the other way, but that's not the issue before us as an appellate court.
I think where there is that prima facie showing and there's no claim raised as to challenging intent, then the court is bound by the four corners of that document. Extrinsic evidence would be admissible if there was some ambiguity in the document. There is not here.
Well, where do you get that from? If you look at section 2-502, it doesn't say anything in it, doesn't put a qualification on it. It doesn't say if there's ambiguity, then you can use extrinsic evidence to show intent. It just seems to flatly authorize the use of extrinsic evidence. So what's your response to the argument that the statute clearly authorized the court to consider extrinsic evidence?
Well, first, that Maine law has consistently held to the principle that extrinsic evidence is only admissible if there's some ambiguity within the document. And second of all, Maine law has consistently held to the principle that oral...
But what do we do about the statute? I mean, we have the legislature enacting a statute that expressly says this evidence can be considered. So what are we supposed to do with that?
So if that evidence can be considered to disprove intent as well as to prove intent, then that would be then that issue would have to be raised at the probate court. And it was not raised here.
What wasn't raised?
The issue of testamentary intent.
Well, I mean, looking back at the record, you know, I was looking at Raymond's memorandum of July 30th, 2024, and he actually said that whether the decedent intended this document to be a holographic will or something else is a focal point of this case. So didn't Raymond clearly put this at issue before the trial?
So that sentence, Your Honor, is within their claim regarding capacity. There was no specific claim for a lack of intent. And lack of intent and lack of capacity are two separate claims under 3407.
Correct me if I'm...
Inherent in the notion of a testator's will is what the testator intended, isn't it?
Absolutely, Your Honor.
So why isn't that squarely in issue here? Particularly given the other claims that have been made, that it was fraudulent, that there was a mistake of fact, that there was undue influence. All of those really circle around the notion of intent.
So all of those claims, Your Honor, underlying that is that there is a valid will that is made invalid by some outside action, by some manipulation. The claim of lack of intent or lack of capacity is a separate, well, testamentary intent from the four corners of the document is a separate exercise.
But you seem to be mixing up, to me, two different kinds of intent. In other words, what was the intent of the document in its bequest? And that's where we have always said that, we don't interpret the document unless it's ambiguous. We don't go beyond the four corners. But that's a different question to whether the person intended this to be the will.
It is a different question, but I think that the same argument is extended there, right? So if we're looking at whether or not he intended it to be a will, we still have to first look at the document, right? That is the primary evidence that we have. In this case, self-labeling is the clearest indicator of intent.
But I guess what I'm struggling with is clearly that is some evidence of the intent. But you seem to be arguing that's the only evidence you can use.
I don't think that that's the only evidence that can be used, because if the petitioner had brought a claim challenging the intent of the testator, then I think you can look at circumstances surrounding the time of execution of the will. But that claim was never brought, and it was specifically excluded from the list of claims that the probate court said were to be heard at trial.
Well, if you were so blindsided and you didn't realize that testamentary intent was at issue in the hearing, Why didn't you say that after you read the judgment to the trial court, who would be in a better position to say, oh, well, you're right, it wasn't really raised? Why did you just immediately appeal?
After 7 years of litigation in 2 courts, Your Honor, we thought that it would be a more efficient process to appeal to the law court rather than return to the probate court.
And if you had known that testamentary intent would have been in play, what would you have done specifically? What would you have done differently in this hearing?
So a number of things. First of all, we would have put on our case first. Procedurally, we had agreed well ahead of time this was the petitioner's case to bring. It was a challenge to what we understood to be an otherwise valid holographic will. If we had understood that testamentary intent was a question, then we would have brought forward that case to prove the intent. We would have had any number of witnesses and ancillary documents to show how he signed other documents, to show how he signed cards.
But I thought you said it was to be based on the 4 corners of the document. So you would have brought extrinsic evidence to bear?
If the prima facie showing of the will was insufficient for the court, then extrinsic evidence would be allowed. But under the Maine case law, it is clear that first the court needs to look to the document. And it makes
But that
sense.
case law, has that case law not been altered by the statute? This is a fairly recent statute. The case law you're relying on, Utterbeck and other cases, are fairly dated. This is a revision to the probate code in 2017. Doesn't, as a matter of policy, the legislature get to make that decision as to what evidence is important on that issue?
Your Honor, as recently as 2024 in Connery versus Shea, this court held that intent is to be gathered from the document.
Well, we questioned that principle. We questioned Utterbeck directly.
And as the chief was suggesting before, aren't those cases really about the testator's intent with respect to the specific bequests that are being made in the will versus the general intent about whether the testator intended a document to be a will in the first place?
It is, and specifically, it's because there was an ambiguity in the document that could not be resolved on the face of the document, and that is why extrinsic evidence was admissible.
On page 30 of your brief, you say that Bobby and Diane lodged a standing objection limiting evidence as only admissible on the issues of undue influence, fraud, mistake, or similar issues. Can you point us to where in the transcript that objection was made?
I can, perhaps not immediately, but by my rebuttal time, I'll be able to point that out to you.
Would you like to, I mean, technically the red light is on. Would you like to wait to rebuttal to have that, or can you get it quickly?
I will take the rebuttal to get that citation for you.
Well,
Yeah, but we can see if there's anyone else.
just to give assistance, you might want to look at the first volume of the transcript of the hearing at 15, where I think you were making a different standing objection as to hearsay, not as to testamentary intent. And so what we're looking for, I think, is where you object on any introduction regarding a standing objection on the intent issue.
Okay, if I may, Your Honor, to clarify that, there was no standing objection made to as intent, because that was not an issue to be heard at trial. All of that evidence that was admitted was admissible evidence as to the other claims: undue influence, fraud, mistake, capacity. It was not admissible as to intent. Had intent been a claim stated by the petitioner or the court, we absolutely would have objected.
Well, I think what we're looking for is just essentially a citation to your statement on page 30 again, which says that there was a standing objection that was made that limited evidence to certain issues like undue influence, fraud, or mistake. So I think we're just looking for where in the transcript that objection was made.
I will take a look. Thank you.
Any other questions from the court? Yes.
I have one question. This is just sort of a more general or contextual question. Your brief begins with a discussion of Bleak House and Fogg and how there's some confusion about, concurrent jurisdiction or what's within the jurisdiction of the Superior Court versus a probate court. And I understand the litigation in the Superior Court took a long time. I guess I'm wondering, though, does any of that have actually any relevance to the particular issue that we have to decide today? In other words, you're not making any sort of res judicata, estoppel argument, anything of that sort, are you?
I think that there is absolutely a collateral estoppel issue here, but I think the result of that was that it clouded the issues before the probate court. In our opinion, all of those issues had been resolved by the Superior Court on summary judgment. Undue influence.
But to be clear, the Superior Court, I mean, despite, whether there's some fuzziness in the overlap of jurisdiction, isn't it clear that only the probate court can deal with a will contest?
Absolutely. And we do not dispute that only the probate court has jurisdiction to determine the validity of the will.
And that's what we had here, was a will contest.
Yes, but what we ultimately had, Your Honor, was a challenge to the validity of the face of the will that we had no notice of.
That's a different issue as opposed to the interjurisdictional
Right.
issue.
But what we ended up hearing were challenges to the validity based on manipulation. And so a valid will becoming invalid because of these other claims. And had those claims been set aside from the probate court because they were dismissed by the Superior Court, it would have made the actual claim that the probate court decided on very clear.
So the argument essentially is that because the probate court perhaps improperly addressed these other issues, it was sort of a distraction and prevented you from focusing on what the real issue was? Is that the argument?
Prevented us from, not necessarily, well, essentially, yes, Your Honor, but not that it prevented us from focusing on that, but it prevented the court from articulating that. Like, it was not an issue for us to focus on. We specifically asked the probate court what were the claims to be heard, and intent was not one of them.
Thank you.
Any additional questions from the bench?
Thank
you, counsel. Attorney Baber, we're happy to hear your argument.
Thank you, Chief Justice Stanfill, members of the court, Brett Baber for the appellee, Raymond Young. One of the issues that I heard no discussion about with appellant's counsel is outcome determinative. They mentioned that it is their burden of proof that they established the signature of the testator, Robert Young. And by statute, section 2502, it is their burden of proof to establish that Robert Young indeed signed the holographic document. The probate court did not make an express finding in this regard, but she observed several times that the evidence was contradictory as to whether or not there was a signature of the holographic document. All of the evidence introduced at this hearing demonstrated that Robert R. Young always signed his name in cursive, Robert R. Young. And indeed, his own son, one of the appellants, Bobby Young, he's also Robert Young, testified that he saw his dad sign this holographic document, and his dad always signed everything in Robert R. Young with big R's. And yet we know that the holographic document, the end of the document, was established to be a printed name, Bob Young. Now, it is entirely possible that somebody could sign with an X or a printed name, perhaps, but that is a question of intent. Whether or not somebody intended to adopt a certain series of symbols as a signature is a question of intent. This court, in a case from some time ago involving a credit union, made it very clear that whether or not something is a signature is a question of intent. Signature and intent are questions of fact. And if these are supported by the evidence in the record, the findings of the probate court in this regard need to be upheld.
I see that the green light is on. Can I follow up on that? Are you essentially saying that when we talk about signature in this context, we're not just talking about whether somebody wrote it. We're talking about more than that, an intent to adopt, I think you argued.
Yes.
And is it really essentially then the significance of the signature in this case, an intersection with the same issue as testamentary intent. In other words, that both of those things really go to, did he mean for this to be, is he adopting this document as his final will and testament?
Yeah, that was one of the major ambiguities the probate court noted, was this inconsistency between the normal signature, which all of the witnesses testified was his normal signature, Robert R. Young in cursive, but it does go to the bigger picture, whether or not he intended this document to serve as his final will and testament.
So the language that we've used in other cases about a signature means an intent to adopt or execute the document. In this case, it doesn't always, but in this case, essentially overlaps or intersects with the issue of testamentary intent.
Yes. In fact, the probate court went into the detail of whether or not Robert Young intended to adopt this document, this holographic document, as his last will and testament. The signature was one major item. The other major item that the probate court noted was that the holographic document, according to Bobby, one of the appellants, was a series of notes that were meant to be taken to his lawyer the following Monday. And if you were to peruse the holographic document, there are a number of items in there that just simply don't make sense in the context of a will, like terminating somebody's employment. He purported to want to give away property that was already conveyed to Raymond. He purported to try to change the transfer of some stocks and bank accounts that were jointly held with one or two of his children, which, according to the probate
Well, I think that the appellants, though, have argued that there was never any question that those additional 3 pages were part of the holographic will. I mean, the holographic will is really only a 2-page document.
Those 2 pages, Your Honor, but it's those 2 pages I'm referring to. For example, page 1, the first paragraph talks about a lease agreement for Young's Lobster Pound not being renewed. Well, that lease was adopted back in 2000. Mr. Young died in 2017. The lease was for 1 year. I note that that was also signed Robert R. Young in full cursive signature. But it was extended orally over the years, and you don't try to terminate a lease through a will. You'd have to go through the forcible entry and detainer process.
But you might think it's important when you're trying to figure out how to dispose of your estate if you're changing what had previously been the bequest, which was that it was the whole lobster pound was going to go to Raymond. But I just want to ask you, I'm a little bit troubled by the notion that I could write out a document that I intend to be my last will and testament, this is my last will and testament, date it, put my name on it, and then after the fact, someone could come along and say, well, but she was having all these conversations with different people, musing about maybe I want to do this, maybe I want to do that, and that sort of should override what looks to be pretty clear intent from the face of the document. So can you address sort of that issue that troubles me a bit?
The question of ambiguity, of whether or not he intended to adopt this document as his will, was raised by Bobby Young during his testimony. He said these were a series of notes to be presented to an attorney. So they could very well be his last will and testament. They could also be a series of notes for his attorney to address the following Monday.
But why would you write?
That is an ambiguity that requires the extrinsic evidence to resolve as to whether or not this was indeed a holographic document. And again, I submit that the language of the document, if you look at it, really does comport with the idea that it is a series of notes to ask one's attorney rather than a final last will and testament.
Then why would one write, this is my last will and testament, and date it? That's on...
It says this, my last will and testament, on 930. It also follows some suicidal notions. So it's more going on here than just a last will and testament. I submit that we take Bobby at his word when he says that these, he said that his father said, you need to make sure these get taken to my lawyer if I'm not around, or if the notes are missing, take a photograph of these. So Bobby testified that these were notes. That's where the ambiguity arose during the course of this trial, in addition to the fact that the face of the document itself, for example, it said that his stocks and bonds in his and Raymond's name So on its face, it's talking about non-probate property. So why would somebody be addressing non-probate property in a last will and testament?
When the probate court issued its order setting forth the issues that were going to be tried, and it didn't identify testamentary intent as one of the issues, why didn't you seek some clarification or amendment to that order?
I believe there is language in there that testamentary intent, the burden was on the opponent of the holographic document.
In the order, you think that language is in
I
there?
think it's cited in our brief, the probate court's order. I'm not sure I can find it expeditiously. And as Honor pointed out earlier, I clearly raised it in our July 3rd, 2024 memorandum. In addition, there's the whole fact that Bobby, one of the appellants who claims lack of fair notice, raised these issues on his own. In the colloquial trial court world, we call it opening the door. Bobby opened the door to these issues if they hadn't been raised. Furthermore, counsel for the appellants in their argument in support of judgment as a matter of law said, and I quote, "The issue is not whether he had good reason to change his will, but whether he intended to." And that's the central issue in this case. I'd also submit it's raised by the idea that we've challenged that this will occurred as a matter of undue influence, fraud, or mistake. It's really the flip side of the coin of the whether or not he intended to adopt the document.
I'm not sure this is terribly relevant, but I'm just curious about these extra 3 pages that the probate court was looking at, but then ultimately decided that they predated the holographic document. Can you just add any explanation about why the probate court was looking at those 3 pages and where they came from?
On behalf of the appellee, the petitioner, at trial, we introduced those to show his signature and how he normally signed important legal documents. So all 3 were in cursive signature.
And do you agree that the probate court decided that those 3 pages did not actually constitute part of the holographic document?
Correct. It actually went through a fairly, Judge Owen went through a fairly extended analysis as to how each of those codicils, if you will, amended his prior will. And the court went through that analysis and made it very clear that these were not part of the holograph that the appellants were tendering to the probate court for admission into probate.
Can you tell us a little kerfluffle about the transcript? I am not going to sign this versus I am now going to sign this. What's your position on that?
We'll take counsel at their word that they checked with the court reporter. We tried to independently verify that, but they wouldn't even return our phone call. But it just further adds to the ambiguity of the context of this document. Bobby testified under cross-examination from my esteemed counsel, Mike Harmon. Bobby testified that he was present in the room and his father said, "Be sure to watch me as I sign this document." And then he goes on to explain his father always signs everything, Robert R. Young, in cursive. And yet we know, and everybody's sort of at trial, like rolling their eyes, because we know that the document said Bob Young. It did not say Robert R. Young in cursive with big R's. So that, again, is where Bobby opens the door to this whole question of his father's, what's going on with this document. And another major factor with this document that this court has noted in the context of undue influence is the sudden major change in the estate plan. For over 17 years, Robert Young had one estate plan that basically funneled the real estate of the Lobster Pound to his son Raymond Young. And then suddenly, on the day before Robert Young's apparent suicide, and I say apparent because there's comments in this note that suggest he is suicidal, all of a sudden there's this major change in how his estate was to be handled. If questions that he was going to submit to his lawyer to address. And it begs the question, well, why this sudden change? And this court, in the context of undue influence, has said a sudden change in one's estate plan is circumstantial evidence of undue influence, which this court, the probate court, found by clear and convincing evidence had occurred. My point here is that it's another indicia of ambiguity as to what's going on with this holograph. We have this sudden change. We've submitted in our additional argument in support of the probate court's finding that Robert Young had this tremendous racial animus against his family, especially when his two granddaughters engaged in
Which
racial
may be why
intermarriage.
he's making that change.
Excuse me?
Which turns out may be why he made that change.
That could very well be, and if that were the reason, and we submit the record is replete with his racism and how it
Well, that doesn't help
impacted his-
you, though. If that's, in other words, you're giving me a reason why he would have made this drastic change.
That certainly could be one reason, Your Honor. And we submit the record is abundantly clear. That was a significant thinking. This occurred 2 weeks after...
But that weighs in favor of finding the holograph valid as a will.
Well, the probate court engaged in more of a salutary approach. She went to the issue of testamentary intent without getting into the racial issue. If this court were inclined to affirm or find in favor of the appellants on their arguments, the court will have to squarely address the issue of whether or not a will can be admitted into probate where it's based on racial animosity. There's clear evidence of that in the holographic
But the
document
cases that
itself.
you're citing on that issue all have to do with bequests that require another institution to act on the basis of racial animosity, as opposed to this is why I'm giving it to this child as opposed to that child.
Well, in this holographic document, I believe it's the second paragraph, Robert Young purports to terminate the employment of Raymond, his wife, and his extended family. Well, why would he rule out his extended family? Because they've been engaged in racial
No, I'm not saying
intermarriage.
that the animus isn't there. I'm saying that the public policy invalidation occurs when, a document, a trust or something like that wants to have an institution act in a racist
I
fashion.
submit that the same public policy carries forward with respect to a will or a testamentary document where one purports to act in a racially hostile manner, Your Honor.
But didn't the
It
court,
would not be sound public policy to adopt it.
but didn't the probate court find that the document was facially neutral?
I would make three arguments in that regard. One, it's dictum. Number two, it's contrary to public policy. Number three, it's not supported by the language of the document itself. So on the one hand, the court finds all these ambiguities, and yet when we get into what's going on with Raymond's mind, and we've got all this evidence that we know it's racial animosity, the court wants to look the other way. I find that perplexing, and I submit that this court should rule as a matter of public policy that a will based on racial animosity cannot be admitted into probate court.
Additional questions from the bench?
But you're not asserting there was any racial animosity beyond the family, per se, as opposed to a separate public institution.
Yeah.
Would that be accurate?
Yes, Your Honor.
Okay.
Thank you, counsel. And Attorney Eastman, I believe you reserved 3 minutes for rebuttal.
Thank you, Your Honor. Justice Taub, in response to your request, the standing objection that's on page 15 of the transcript is the one referred to in the brief, just a standing objection to hearsay. And that would apply to all the claims that were brought.
Right, but your brief suggests that there was a specific objection made saying that, evidence can only come in for the purposes of undue influence, fraud, et cetera. But the actual objection that you're citing to is just a hearsay objection, correct?
That's correct.
Okay.
Appellee stated that it was our burden to prove the intent, and that is incorrect. Our burden was to prove due execution of this will, and that refers back to Section 25022, that the material provisions and the signature.
And 3407, it says it's the contestant of a will has the burden of establishing lack of testamentary intent.
Correct, right. So again, our burden was under 25022. It was undisputed. The petitioner testified that he agreed the holograph was in the handwriting of his father. And In the transcript, he was asked, "You agree this is in your father's handwriting?" You
I don't
agree
think they're suggesting anything different than that.
It's not. As to the form of the signature, the statute does not require any specific form, and the case law clarifies that further, that any form of signature is sufficient under
Again,
the
I don't think
statute.
that's the argument. I think the argument is that regardless of the form of signature, but the form may be evidence that it wasn't intended to adopt this document, that a signature means more than the person wrote it. It means also that they intend to adopt the document.
So then, if we're looking at intent, again, we start with the document, right? Did he dispose of his assets? Was it in contemplation of his death? The signature, where the signature is it signed off as like a subscription, which it is. This document meets all those requirements of intent, and it meets the statutory definition of a holographic will. What did he have to do to have a valid holographic will? And if that is not the case here, then how can any holographic will ever be upheld if all it takes is for someone to come in and say, "That's not what Dad told me"? People are allowed to change their minds. This was an informal document. It makes sense that it has things that a lawyer would not put in a will because he wrote it by his hand. That doesn't mean that it's invalid. It is valid in accordance with the law, and it should be upheld.
There don't appear to be additional questions. Thank you.
Thank you.
Thank you, counsel, for the argument here this morning. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
Good morning, you can be seated. The matter before the court is State of Maine versus Timothy Burns, Rustic 25417. I see counsel are present, and I'm assuming you're ready to proceed. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to simply identify yourselves for the record together with the party you represent, starting with the appellant.
Thank you. I understand we're using this microphone alone, so I'm going to get a little closer. My name is Neil Prendergast. I'm here for the defendant, Timothy Burns.
Matthew Hunter. I'm here for the appellee of the state of Maine.
Thank you. Attorney Prendergast, we'd be happy to hear your argument here this morning.
Thank you, Chief Justice. May it please the court, my name is Neil Prendergast, and I represent Mr. Burns in this matter. I didn't reserve any time, so...
I see that, so, okay.
Whatever the questions the court has, please ask away.
So can we go to the issue of prosecutorial error in this case?
Yes.
It is a little disturbing that the judge specifically warned the prosecutor not to say certain things, and then he proceeded essentially immediately to continue to say it. However, in this case, defense counsel objected.
Correct.
And the objection was sustained. And they objected, and the objection was sustained. I mean, and there was no additional relief sought. So where are we on that?
Well, I think that it's still prosecutorial error, and I think that...
It may be prosecutorial error, but what's the consequence?
Well, I think that I have argued that I think Mr. Burns was likely entitled to a mistrial. I think the strange part for me reading the transcript probably was that the word mistrial was not used, and it was not requested for relief. I have to concede that. However, given that, you know, the error did in fact happen, and I think that it probably did constitute what this court has called vouching and what the Superior Court Justice said was vouching, I think that that, especially coupled with some of the other things that happened, I think that entitles Mr. Burns to a new trial, and I think that there was an error that affected his substantial rights.
Well, what's our standard of review on that? I mean, are you saying that the error was so obvious that, that it was obvious error not to declare a mistrial as opposed to simply sustaining the objections, which, it'd be different if it wasn't sustained.
Well, one of the objections was not. There were three objections, two of which were sustained, one of which Mr. Collins moved on from before the court addressed it.
The judge didn't rule one way or the other.
There was no ruling one way or the other. So,
but we can assume he probably would have sustained it.
Okay, but you can make that assumption. I'm going to choose to say that I'm not going to make an assumption on behalf of Superior Court Justice. But I think to answer your question, I mean, yes, the word mistrial wasn't used, but I still think that I believe that it's a harmless error analysis. But whether or not the court agrees with my analysis, it's a harmless error analysis. I think the court still under Rule 52 and also under, I think it's State versus Gervais, paragraph 20, has the ability to go with an obvious error analysis where there would be a plain error that affects substantial rights. And I think not doing something about this was an error that affected Mr. Burns' substantial rights. I think, in fact, what we have here is a district attorney who was the elected district attorney, which the jury would have known from jury selection that he was the elected district attorney, who's sort of clothed in the, in the prestige of the office. And what he's saying about the evidence is we know. And oddly enough, this particular prosecutor in a previous case, I think it was also State versus Gervais, conceded that I think could be problematic in a previous case. If I think is problematic, I would make the argument that we know is a couple of steps further. I mean, really what the prosecution's argument is that we, the state and the jury, know all of this stuff. Well, he's basically commenting on what.
Well, we certainly suggested, I think the case was decided after the briefs were in this, it may have been decided after the briefs, but we certainly suggested in State versus Brackett that the prosecutor stating that something we know is particularly when the when that was combined with some lack of reliability of the underlying evidence might be problematic. And we specifically said that.
Right, okay, maybe I missed that.
It's a 2026 Maine 9.
Okay, maybe I didn't add that in my brief. I probably didn't. I probably meant to bring something to that up. But I think I think it's problematic that the prosecutor is saying we know, and I think it's especially problematic given the way that the state argued its brief, where it basically says this is a matter of style, and it's not, I mean, that's what's in, the state's brief, is this is some kind of a matter of style.
But even assuming we agree with you that it's problematic, I mean, I think you're still left with a pretty big hill to climb on the obvious error standard.
Well,
Well, I mean, because the judge did sustain the objections and no additional relief was, so that, there is no request for a mistrial.
There was no request for a mistrial, but I mean, I think that I would posit to you that when a judge tells me not to do something in a trial, I don't take that as a suggestion.
I don't disagree with you. It's a little
As a defense
disturbing.
attorney, if you try something like that at a trial, there's going to be an off-the-record conversation with you about whether or not, let's face it. And so, like this, the fact that the prosecution treated this as essentially, something that was sort of a,
But that's a slightly different issue than the obvious error for the mistrial.
Well,
I agree with you on that, and were Mr. Collins here in person, he might have gotten a bit of a tongue lashing, but he is not here in person.
Right. And I didn't argue misconduct. I know the court separates misconduct and error, but I mean, the underlying issue here is how, at some level, as the defendant's representation, I mean, I still think that there's a problem here, and I think that he was essentially deprived at some level of a fair trial, given what happened in the closing argument. I think that's...
Well, and I think we made clear in White that we can also use our supervisory authority to say, you've got to stop doing this, and if you don't, there will be consequences, even if otherwise it would be harmless error.
I agree, and from what I can glean from what Justice Nelson said right before closing arguments, about 15 minutes before, that's what he was doing, was basically saying, I have some authority here to highlight these issues, don't do this. I don't want this to go to, to go to an appeal. That's right in the record on page 19 of, volume 2, the second day of the trial transcript. The judge says, this is not something I want to do. This is more than, this is, in the court's opinion, this is more than style, and I understand we disagree, but that's my ruling, and I don't want this to go on appeal. So, I mean, there we are. It couldn't have been clearer at some level to the attorneys that that this was not going to be considered acceptable. Now, obviously, the judge didn't grant a mistrial sua sponte, and it doesn't have to.
And shouldn't we take that into account? Because the judge is there witnessing the performance, for lack of a better way of putting it, of the state's attorney, and that line between prosecutorial error and misconduct is something that the judge was in the best position to observe.
I think that, well, I mean, yes, the judge was in the best position to observe it, and I don't think I mean, I would not make the argument that you can't take it into account, but I would say even if you do take it into account, it's still problematic. I mean, there's no good way as a defense attorney you have to deal with a situation like this where a judge says, this is vouching, don't do it, it gets done anyway.
Could have asked for a mistrial.
Right, but I guess and I suppose you're correct, but I think my argument would be, how many more times does a defense attorney in this situation have to go back to that well when a judge has said, don't do this, and it gets done anyway? I mean, technically speaking, because I'm a little more fiery than some people, had it been me, I just would have said, we need a dismissal, with prejudice. If someone's not going to obey the court's order, then what am I supposed to do? How am I supposed to try a case? How am I supposed to get my client his constitutional rights when the court says, don't do this, it's legally problematic, and then it gets done anyway? I would also state, I think the trial judge was in a good position, but I think what makes this particularly disturbing to me is not that it was a situation where it was like it happened once. You know what I'm saying? Because when something like this happens once, anybody can rehearse a closing argument and have a phrase or two that they use. But it was used 3 times before the first objection, and then that objection was sustained, and then a couple of times after this, and then the second objection was sustained, and then it was used again. I simply don't understand how, when at some level, when you're a defense attorney, if the court orders the attorneys not to do something, and then it gets done anyway, and it's of this magnitude, that the burden is entirely on the defense attorney to say we need a dismissal. I understand that there are rules, and I understand that...
But are you advocating for a bright line to say if the judge says do something or don't do something, they don't follow along, it's repeated, that at that point, without anything further, entitles them to some relief on appeal?
I would think it's always difficult to argue that there should be a bright line rule, but I'm gonna say in a situation like this, yes. I mean, I don't know how else you manage this as an attorney, where a court tells you not to do something and then you do it anyway, and then sort of go ahead. I'm sorry.
Well, you do have things in the toolkit. You have the motion for mistrial, motion for sanctions, motion for dismissal, all the rest of it. And shouldn't something be hauled out of that toolkit at that point if you're really looking for the affirmative result that you're looking for here today?
I mean, I can't say that it shouldn't have been done at the trial level. I can say that I've had conversations with numerous people about it, and I doubt the public defender's office won't be asking for mistrials or dismissals ever again based upon this case, and so I'm sure that that record will be preserved ad infinitum from now on.
Can I ask you in the time you have remaining about the change log?
Sure.
And this is some new territory for the state of Maine.
Yes.
And the request, you weren't trial counsel.
I was not.
And trial counsel asked for automatic discovery,
Correct.
16A, and as you look down through the text, obviously doesn't mention change logs or analogs.
Yep.
But the judge jumped right over to 16C, which is discovery upon request,
Right.
which I think would broaden at least the opportunity. But the question I have for you, apparently the change logs, in this case, the court found that there was nothing to suggest there's been any deletion, nothing to suggest any substantive changes, and all automatic discovery had been provided. Does that kind of moot the issue for us here today, the fact that we shouldn't reach the issue because in this fact it wouldn't have produced anything under our existing jurisprudence?
I think the way I approached it would have been something closer to if the state had simply filed a reply to the motion to compel and said, we reviewed these records, we're not going to use them at trial, there's nothing there. I don't think I have anything to talk about at all, right? Because if the rules were followed in that sense, that there was some kind of affirmative statement that the record had been reviewed, but I don't know what exactly is in the change logs.
But it seems like what you're arguing for then is essentially you have to always produce the change logs because you don't have anything to say that in this particular case there was something that should have been.
Well, I don't have any evidence that there was something particular. I agree with that, but I think in this, I don't think that they would have to produce the change logs in every situation as long as someone's reviewed them and said there's nothing there.
Okay.
I think kind of what I keyed in on at some level was that didn't really happen. When you take a look at the transcript from the motion hearing, the state is arguing all kinds of other things, but not saying we reviewed this and there's nothing there, we're not going to use it at trial, right? And so under American Discovery, if a prosecutor reviews the stuff and says we're not going to use it at trial, then that's where the conversation ends. That never happened. It became a policy argument about how it's too difficult for us to turn this stuff over, so we shouldn't have to.
You're arguing for an ad hoc rule then, that if the state comes forward and says we've reviewed the change log and wow, there's some stuff that's pretty important here, then that transfigures that into something that's discoverable. If the state certifies we've reviewed this, nothing substantive, no deletions, then there's no requirement. Is that the rule you're looking for?
I think given the way the rules are written, I think I'd be required to agree with that analysis. Whether I agree with whether or not I think it would be entirely effective is something else. But given the way the rules are written, I think that, when the rules are obeyed under Rule 16D2 and that reply is filed within 7 days, it says we're not going to use this and whatever else, then I don't know that necessarily it goes any further. But the fact that that didn't happen means at some level that the rules kind of weren't obeyed, and then we get to a point where we're arguing about policy instead of, what actually happened in terms of the discovery.
You are, but don't run away. I'm going to follow up with one more question on the other issue, which is the state's conversation with the witness after the witness had finished the testimony and then the conversation during. Was there a sequestration order in this case? I mean, typically, not always, but oftentimes sequestration orders also prohibit having those conversations and then recalling a witness or in breaks.
The answer is there was one, but only after this happened with this witness. So
Okay,
as far as I
thank
could
you.
tell, I could not find on the
You
record
didn't
that-
argue it, so that's why
No,
I was just curious.
That's why I did not, because if there had been one, I would have been touting that as saying there was a sequestration order.
Thank you.
Sequestration order was a violation. So, thank you.
Any other questions from the bench? Thank you.
May it please the court, I didn't reserve any time. I'm ready for questions.
What are we supposed to do with this? I mean, let's be clear. White was the same prosecutor where we got a little fed up and decided to use our supervisory authority. In this case, we have a judge saying, Mr. Collins, don't use the word "we know." And then he does it. Sustained, does it again. I mean, you can argue that it's reflex, but doesn't he have an obligation to control himself? And what are we supposed to do when that happens?
I got acquainted to this case by reading the transcript. I wasn't there, although I know Attorney Collins, and so sometimes you hear their voices when you're reading. And what came through to me was it looked like he was trying to resist using a phrase that he's used probably consistently for 25 years. And he struggled with it during that first part of the
Regardless,
closing.
isn't that his job to resist?
Yes, and I think he ultimately managed to do that after several objections.
So is it preserved error? I mean, you know, the judge told him not to do it, he does it, it's objected to, if the objection is sustained, it's objected to, the objection is sustained?
Well, I don't think there was an error by the court. The objection was proper, it was sustained, there's no problem there. And then
You state the objection was proper. Why didn't you admit that it was an error in your brief?
I didn't write the brief, but I'm ready to admit that it's an error right now. There was an order not to use that phrase.
Was he afraid not to come here?
But with respect to whether the court ought to, on its own, granted a motion for mistrial, in the absence of a request, the trial court's not really in a position to know whether the defendant wants one. And the mistrial is really appealing post-conviction. But, you know, at the moment when a request would have been timely before the verdict, it really hadn't gone that bad for the defendant. From my reading of the transcript, there weren't a lot of witnesses. The mother of the victim had some difficulty recalling the date when this was reported. And then the cross-examination of the child victim went really well from my perspective for the defense. I don't think that the absence of a request for a mistrial was unintentional. I don't know that I would have wanted a mistrial if I was the defense attorney at that point. I would have after I know he's convicted, but while the outcome's still uncertain, I don't know that I would have requested a mistrial in that moment. I mean, it didn't go that bad.
So what are we then also to do with we have a witness testifying, the mother of the victim testifying. The testimony is complete.
Yep.
And then they go out in the hall and the prosecutor says, I think you got this wrong. Can we refresh your recollection? And let me put you back on the stand now to correct. Why? I mean, is that okay to do that during a break after you've said the witness is done? Or, if he thinks there's something and she's getting it wrong, he can impeach or refresh recollection while she's on the stand the first time.
Mm-hmm. I think that, like Neil mentioned, I didn't see any order for sequestration early in, but I think if one had been made, and it hadn't been made it hadn't been more specific than just simply the witnesses are sequestered, ordinarily that just prohibits the witnesses from speaking to one another. It wouldn't prohibit a party from still talking to their witnesses about the case. So I think that is ordinarily allowed. And then in this case, in order to, you had to ask the court to recall her, and the court wanted to know why, and the discussion out in the hallway is described, and then the defense was allowed to explore that through their cross-examination after the fact. And I agree with Attorney Collins on the point, his argument that he made to recall her is ultimately the goal was to get at the truth in that moment, and this was in furtherance of that.
In your view, I'm a little bit troubled by this notion that the witness is done, and then you could say, oh, I forgot something, I forgot to clean this up, and then you can go talk to the witness about it. But I wonder if, in your view, it's okay in this case, because what we're talking about is sort of a document that is definitive one way or another about when Mr. Burns moved out of the house, versus maybe it would be worse in a situation where the witness just, says something inconsistent with a prior statement about kind of the nature of the offense, what happened, that's not sort of independently corroborated by a document. Do you agree that that would be worse, and maybe we would be looking then about, maybe it was an abuse of discretion to allow that sort of recall or refresh at a break?
I think it would be worse. And I mean, in this moment, in that moment when the judge is deciding whether or not to permit that or not, the fact that it is a reference to a document that's sort of beyond dispute, it does make it more solidly within the court's discretion, from my perspective.
As you know, when refreshing recollection, the typical protocol is the witness is equivocal or can't recall, and you ask, is your present memory exhausted on this? Yes, it is. Would it help if, could I refresh it with the document? Yes, it was. Take a look at this. Is your memory refreshed? Yes, I know that it's this and this. It was a little bit different here because there's no indication from the witness on the stand that her memory was flawed, but obviously the attorney thought that was the case and presented the document to her outside the courtroom. And we don't know exactly what the conversation was that took place out there. I'm not casting any aspersions, but it does put a cloud over the circumstance. It seems to me the proper route would have been to technically impeach the witness by saying, I'd like to show you this. After looking at that, do you wish to modify? But that happens in the presence of the court and the jury. If you're not conceding any violation of the rules, is there a best practice that was perhaps violated here and it should have been handled differently to avoid that cloud over the proceedings as to what did happen out in the hallway there? I'm not suggesting anything bad did, but with those choices, should that have taken a different course?
Do you mean in terms of like sort of creating a record of what that discussion looked like between Attorney Collins and the witness, or?
I think if it's done, yes, in a nutshell, that's what it is. Let's take a totally different situation, nefarious situation, where the lawyer wants the witness to testify, otherwise takes him out in the hallway and offers up some incentive or strong-arm tactic to make them change their testimony. We see that in the movies. Luckily, we don't see that in real practice here. But I'm simply asking, shouldn't the state be concerned about the possible cloud that would hover over these ex parte goings on in the hallway, as opposed to simply going to the witness on the stand and say, you said A, I'd like to show you this document. After reviewing it, do you wish to say B, or something like that? Policy, best practice.
I think it could have been done better than it was, more cleanly than it was. I don't know, and again, my.
How could it, what would be the appropriate thing to do in this situation?
Well, I think if they had the protection order while she was still on the witness stand, right? Remember, that was obtained, I think, after she got off the witness stand, so that it wasn't necessarily possible to do that with her the first time she was up there. And I don't know why, I don't know why that we didn't have that beforehand, although, and it gets a little bit awkward because it wasn't the sort of benign document that you could just talk about. They had to cover that it's, not a protection order, don't reference a protection order. It would have worked better if we'd had the protection order when she was on the stand initially.
Even if you didn't, going to posit to you that maybe it would have been better if you saw there was an inconsistency, but you were missing a document that you needed to resolve it, to share that with the court and defense counsel outside the presence of the jury and say, we're not quite done with this witness. Can she be subject to recall later so we can clean this issue up, as opposed to what Justice Mead was mentioning, which is an ex parte conversation in the hallway. So I'm positing that as perhaps the better practice. Would you agree with that?
Yeah, anything that would minimize the cloud that's apparent when you read this transcript would be a better practice. I think he might have learned about the protection order in the hallway. I don't know that, the way I read this, I don't know that he knew about that before she was done and they entered the hallway.
Yeah, we don't know what happened in the hallway. Therein lies the problem. Can I ask you just quickly about the change order? And this is a little bit extrajudicial, but do you know if the Spellman system is being used in other districts other than yours?
I thought it was everywhere. State police use it. And the sheriff's department use it, and they all tend to use the same. My understanding is the same thing.
So it's a pretty routine thing. It isn't reflected in our rules because it's new. We're not aware of it. Is there a problem with making change order data available as automatic discovery?
So I don't know. I know that the testimony at the hearing on the issue was that it takes somewhere between 30 and 60 minutes to generate
But I think the
a report of
command,
it.
that when the administrator can do something like print change order and hit the button, and then the database will put the stuff together and eventually get spit out. Is there an argument that it's onerous or burdensome?
I think that was the argument at the hearing. When you look at the reports, there is, I think the report does try to document in some ways the points in time when things are added or changed.
Well, let's say it is somewhat burdensome. Is there a reason why it shouldn't be included in automatic discovery if these reports are being changed or edited?
I think if it were not, it's hard to say because I don't know exactly all the information that's contained in those change logs.
Well, let
That's
me
going to
ask,
go to a question I had about this. I mean, there is an obligation to disclose automatically any electronically stored information that the state intends to use in a proceeding, correct? Does your office, or do you know of any other prosecutors' offices, have a policy or a practice of reviewing these change logs at any point? Because there could be material changes made that have either inculpatory or exculpatory information. Does your office make a practice or have a policy of reviewing these?
No, I've never seen a change log.
I have a different question, which is, you agree that in this case, the defendant requested in writing these change logs?
Mm-hmm.
And I'm really raising this because we seem to see this all the time. Under Rule 16C, when the defendant makes a request for additional materials, in other words, assuming it wasn't part of the obligation for automatic discovery, the state's responsibility is, upon receipt of a written request, the attorney for the state shall, within a reasonable time, provide a written response to the defendant that either provides or notifies it will be or that it won't, and whether the state objects. Frankly, it seems like the state never provides a written response, and so I don't just mean this case, but in my observation. But that's the obligation. And so should we just say, is it like, well, if you don't respond, we assume it must be granted? Why shouldn't that be the rule? The obligation is to respond in writing, and that wasn't done here.
The obligation definitely is to respond in writing. I know, I could tell from the transcript that it was objected to. I didn't see a court filing in writing responding to it. It should have been responded to if it was.
But I guess what's the consequence of that? So I think about it in the civil context. If one doesn't object according to their obligation to a motion, for example, within a specified period of time, it's deemed that you have no objection. Why shouldn't we do the same thing?
I think a trial court could do that. I don't know why they couldn't,
But should we just say, that's it, that's what we're going to do? If you don't respond, it's deemed that you have no objection, therefore they should have gotten it in this case?
I think a better way to address it would be to, case by case, and allow the trial court to address it, because they would have a better idea of whether the extent to which the lack of the written objection
I guess I'm
was an
just a little
impediment.
disturbed by the fact that that seems to be the practice across prosecutors' offices in the state, and I don't mean just yours, that there's just don't seem to be written responses.
I think most of the requests I receive are by email, and most of the responses back are in email. They wouldn't necessarily result in court filings. So I don't know that there isn't an email thread related to this.
Thank you. Any additional questions from the bench?
Just one quick follow-up on that point. So if you don't respond, the defense only remedy is to file a motion to compel, creating more litigation and time in the courtroom for the judges.
I agree with that. I think a lot of times we get I'm going to refer to it the boilerplate discovery request. It contains all the items that are automatically discoverable, and once in a while there'll be a
I'm familiar. I had one when I practiced law a million years ago.
We all have one, right? and sometimes they you don't see that in the 3-page request, and sometimes they don't get responded to for sure.
Additional questions from the bench? Anyone? Thank you, counsel.
Thank you.
Just a couple of basic points on rebuttal. I think just to make it clear, I believe that during the motion hearing, Justice Nelson stated on the record that there was no written response filed by the state. So there was an oral response that was discussed. but it
That's
was clear
what
from the
my
court.
understanding is as well.
The court made basically a factual finding that there was no written reply. And I'm not going to disagree with the court that in many cases I see there is no written reply that's ever done. And then your only remedy as a defense attorney is to file a motion to compel and spend more time. And so I think that's, but I also think that generally speaking, in my experience as a defense attorney, the way this works is not just that. It's that you get a case, you go to a dispositional conference, you say you don't have discovery, the judge basically says, I can't do anything, go file a motion, then you have to have at least one more dispositional conference before you can get to have a hearing on the discovery. And so one of the things that happens is discovery is basically chronically not turned over prior to these dispositional conferences, and it wastes an inordinate amount of time. If the court is worried about moving, the cases more quickly, the way to do this is to require that the stuff is disclosed before a dispositional conference, if nothing else, because the rules require the defense attorney to be available to have a meaningful discussion about a resolution of the case. You don't have all the discovery, you're not doing your job under the Sixth Amendment of the Strickland standard if you're trying to negotiate a case where you don't have all the discovery yet. There's literally a pocket there where you go into a conference where you're supposed to settle a case and talk about a plea, you don't have discovery, you can't do it. And this just keeps going on and on and on, which is one of the reasons why cases can sometimes take 6 months to a year to get to a point where they're even on a list for jury selection.
Well, the irony is it's also a benefit to the state to file the response, so you don't have to go to the dispositional conference and have these conversations. It's all right out there.
Yes, but the way the practice, at least is going in Aroostook County, is precisely the opposite of that. I think I will leave it there in case the court has any other questions, except for the fact that in terms of the witness retaking the stand, all of the court's language was sort of steeped in Rule 612 of refreshed recollection, but again, there was never any testimony that...
Well, I'm going to suggest to you there actually was.
Okay.
Looking at the transcript at page 30.
All right.
The testimony just changed. When she said, do you have an idea when your relationship ended? It ended January of 2019. Well, I'm not sure exactly the year, but it ended in January. And then she backed it up to, so it kind of went back and forth.
But I did want to address one other thing. As a defense attorney, this is as a defense attorney, you're taking an awfully large risk if you approach a witness in a hall and their story changes.
Understood.
Far larger one than a prosecutor would be taking, because there's always an outside possibility that somebody makes a claim that you tampered with a witness. And that's something that a defense attorney is probably never going to do if they're worried about that, because that's going to create a whole different ball of wax and a whole new can of worms for you if a witness you talk to in a hallway changes their story as a defense attorney. Thank you.
Any additional questions from the bench? Thank you, counsel. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, we are in recess.
All rise. All persons having anything further to do before the honorable justices of the Supreme Judicial Court sitting as the law court may hence depart and give their attendance here at the call of the Chief Justice as the court now stands adjourned. God save the state of Maine and this honorable court.